Miriam Angel and Salim Barisa. You know what? And today being Legal Tuesday, you know we always have an advocate of the High Court. And today in studio we have none other than Asya Mohammed. She is an advocate of the High Court. And we're going to look at matters that are trending in our legal
illegal field.
Yes, thank you so much for thank you so much for doing that. In
the meantime kuna Patrick Destopa hapa anafuatilia, lakini kuna Ramadzoga Karema Mchelsea, ni shabiki wa Chelsea, Kalu de Costo Kid, Chimina Amina, David Fondo, Bayada the Prince, Duncan Thethe, Farhad Jeffa, Rieri Katumbua, Shampoos kutoka Malindi, journalist Double KR yule ambaye kwamba anatuma ripoti hapa kila siku kila wakati wa kick-off, Mtemi Halisi, King Said, Jacob Musilibi, Evans Nelson Kombo, Martin Katana na wengine wengi, kina Charity Bahati hao kutoka Malindi kule, shabiki wa Arsenal wanafuatilia.
Thank you so much for staying tuned. Now, in studio we have Asya Mohammed. She's an advocate of the High Court. Good morning.
Good morning, my dear.
How are you doing?
Salama kabisa.
Karibu sana.
Niko poa.
Tuko salama. Karibu sana.
Asante.
Yes, so Legal Tuesday, of course, we look at different cases. And today there was an article on the Standard newspaper on the 10th of August, of course, 2025, where 3 teenagers challenged a blanket ban on sex between adolescents, right?
Yes.
So let's break it down. So the first minor, okay? These are the questions. The questions, I'll ask the questions later on. So it says that should teens under 18 engage in sex? That's first question. Is there such a thing as consensual relationship between teens? Do they have the mental capacity to consent? And does it amount to defilement, right? So these are the questions that the High Court in Nairobi will consider in a case filed by 3 teens challenging the Sexual Offences Act for allegedly ignoring consensual relationships among minors. The first minor, codenamed HSO, is 17. He faces charges at Makadara Law Court for defiling a 15-year-old girl whom he claims was his lover on January 8th and February 17th in Riruta. However, his lawyer argued that the criminal case is founded on a mutual relationship between the teens. The second teen, codenamed A. Moore, was charged in 2023. He said he was charged with defiling a 17-year-old girl with an alternative of touching her inappropriately and against her will. This was alleged to have happened at Lakisama, Nairobi. The alleged victim, codenamed TA, is the third petitioner in the case. The teen said she is 19 years old and AMO is her husband. She further stated that he was charged while she was at the age of 18. Is there such a thing as consensual sex among teenagers?
Currently in our in our laws, there is nothing of such because according to the age of majority is 18 years. From 18 years, you are termed as a sound and reasonable person. And you have the capacity to make an informed decision. But anybody below the age of 18, they are termed as children. So they have the definition of a child. And according to the Sexual Offences Act, under Section 8.4, actually under Section 8, it speaks about defilement and the liability that comes with it if you are charged with defilement in different age gap. For in this instance, we have the age of sana 15, hapo to 17 years. So in such bracket, they normally are they are being charged under Section 8.4, and they can be in prison for a term not exceeding 15 years. So you can see the consequences of such act because they have been deprived the element of consent, you see. And in that same act, it gives the definition of a consent. What is a consent, you see? And who gives the consent? So the two acts complement each other, the age of majority and the Sexual Offences Act. However, in the same act, tuseme in instances whereby you are an adult, you are of age of majority, 18 years, and you got into a sexual activity with a 17-year-old girl or boy. So in that sense, there is a defense around it. If this person now, Section 8.5 brings defenses when it comes to a charge of defilement, such as if that child presented themselves in a manner that they are presumed to be adults, and that you took reasonable measures and you were ascertained that this person is an adult.
Asya, in this case where both the two are teenagers, right? They're below the age of 18.
Yes.
Is this considered as defilement?
Yes, absolutely. It's considered as defilement, and that bears a question like, is it a high time for us as society to reconsider our laws because of the trending, culture that is emerging?
Wait, why is it considered as defilement? Because when we say this person is 17 and the lady is 15, and they also claim that they are in a relationship, who are we charging here?
That's the thing. Unfortunately, the person that bears the burden most of the time is the boy child. Ukiangalia pale, perhaps it's the lady.
They're both teenagers.
They are both teenagers. Perhaps it's even the lady that initiated that relationship. But majority of the time, women seem to be vulnerable, and men, they take the fall. Ukiangalia pia on our records, in children's court and so on and so forth, you'll find that majority of the time, the boy child ndo ako under scrutiny. But the girl child anaonekana ako vulnerable, which is quite unfortunate. But however, there is diversion tactics, whereby the prosecution, most of the time when they see that there is that differences of 1 year, they tend to tag that as Romeo and Juliet situationship. So they can use, they have the power to use diversion in such instances, and avoid to charge the perpetrators in such in such dimension.
When we look at, because you mentioned the Sexual Offences Act, under the Sexual Offences Act, what is the legal basis for charging minors, again, under the age of 18 with defilement, even when the sexual relationship is consensual and non-coercive?
Yes.
Yeah.
So long as that child, like I said at the beginning, the age of consent, according to our laws, is 18 years. That's the time you are tagged as a reasonable, upright, and person that can truly understand what is right, what is wrong. But anything below the age of 18, you are termed as a child. Yes.
So in this case, what happens?
The law takes its course, because if you are 17 or 17, 16, 15, be it 10, if you engage into such sexual activities, you'll be charged with defilement. There is no exception. The only defense that you can bring in is when a child presented themselves as adults and you presumed or you took all reasonable care to confirm, or you did your due diligence and you are, you are assured that this is an adult you're dealing with and not a child.
How can mtoto ajipresent kama mtu mzima? How?
Mambo mingi. Unapata umeenda club, umekaa pale, mtoto anakunywa pombe na watoto wako na mwili mkubwa labda. So uwezi at that point, labda you're already intoxicated, unamwambia una miaka mingapi, akudanganya na miaka 20 na tayari unamwona anakunywa. And you know, in our country you can only sell alcohol to somebody of the age of 18 plus. Or I don't know if that has been revised, but according to my knowledge, it's supposed to be 18. So long as you have an ID, you can purchase, yes, such kind of, or you can consume such kind of goods. Lakini sasa, you see, in such incidents, kunao wanawake watakudanganya, ID yako, okay, mbona ukumuliza ID, ukamuliza ID yako iko wapi? ID imepotea na ifatilizia. So unaona, you asked, they lied. Kuna ile situationship ambao zinakuweza kufanya wewe ukafikiria kwamba huyu alijipresent kama adult.
Now, swali jingine linakuja hapo, unasema kwenye masuala ambayo nafikiri Miriam ameyafuatiliza hivi akiyakokoteza kwamba hapa hawa wote ni watoto 17, 15, 17, 16, 16, 17 wote ni watoto but majorly vile ambavyo umeeleza culprit anakuwa mtoto wa kiume na hawa wote in the beginning walikubaliana kuwa kwenye hili tukio na hili tendo.
Ndiyo.
Why is it mzigo unapatikana kwa mtoto wa kiume?
Ndo nasema kwa sababu mtoto wa kiume ni nadra sana kwenda kupeleka complaint polisi ama wazazi wao kutoka kwenda ku-complain such kind of incident. But mtoto wa kike kama mimi mzazi, mtoto wangu nimejua ameingia kwa tendo la ndoa, nitahadhibika, nitakasirika kwa sababu hiyo ameenda contrary to our customs, to our value, to our principles, to our religion. So I will want justice court in court for my child. So unapeleka mbele hiyo complaint. Ukipeleka pale police station, mtoto wa kike atahadithia upande wake. Mtoto wa kiume ndo atashikwa, itafanywa uchunguzi, atashikwa. Kushikwa zitapelekwa kwa DPP. DPP atarecommend that akuwe charged kulingana na ile kesi. Sengine labda mtoto ako na mimba tayari, si unaelewa? Hawajui jinsi ya kujikinga ama hawajui kutumia kinga katika tendo la ndoa. Unaona? They lack that information in short. So in such incidents unapata once it's placed on the table of the DPP, some of them with tend to divert such cases, especially when the age gap is 16, 17. You see, or 15, iyo age gap ambao wajapishana sana, 1 year. So they normally tag that as Romeo and Juliet situationship.
What is that Romeo and Juliet situation?
Ni mapenzi. So unasema like they are young teenagers, they just gotten involved in love, they don't know anything about love, they perhaps seem to understand love in a sense that it's about sexual encounter, you know, they are in that exploring aspect, you know. Na mapenzi ya Romeo and Juliet, if you've read the Shakespeare's poet, you could understand what that term really means. So they get diverted, and then wanapewa, let's say, some counseling. So they take mitigation hapo, some counseling or anything hapo that will require their attention, and then they are let go.
So you're saying cases of defilement could be diverted?
In some instances, yes, in such kind of situation, but most of the time it's not. Most of the time it's not.
What would warranty a diversion of a case of defilement?
For instance, recently there is a case that happened in Kilifi. So the DPP tend to divert that, and because using section 8.5 of the Sexual Offences Act, because one of the defenses that the 22-year-old man tend to have relied on is that this lady presented herself as an adult.
Okay.
You're hearing?
And we'll bring up the case in Kilifi.
Yes.
The case in Kilifi later on. You spoke about consent. When you say consent, who gives consent?
Exactly my point. A person can only give consent if they are of the age of majority. A child can never give consent, be it in a sexual way or be it in any kind of transaction. They do not have the capacity to give consent. That is what the law says.
Okay.
So the question that comes in mind right now as I sit here, does this mean we need to reform or we need to amend our laws? And because as you can see, there are so many cases of Romeo and Juliet, let me call them that way, the age of 16, 17. So do we need to reduce the age of consent to such age because of the cultures, the emerging things that are happening around us. Because I don't think currently there is a child that does not know about, let me call it as it is, sex. So again, another question we need to ask ourselves, do we need to introduce a curriculum of sexual education in our schools? Such curriculums are very beneficial to our children.
They're there.
They're there.
Yeah, we learnt about sexual education growing up. You did, right?
In school, formal way. Mimi, I remember mzazi wangu akineka chini in an informal way.
Yeah.
But in a formal way in school, you're being told to abstain, you'll be told, but you're not being told the consequences in depth.
Okay.
And the time they introduce, they just tell you about the reproductive system. So tayari, what that does to a child, you're bringing curiosity. If a child of 11 years, I don't know, 11 or 12 years is being shown, this is how a vagina operates, or this is how a vagina is, this is how penis look like. So you're bringing curiosity. And then now there is the aspect of we live in a global village. These smart devices, they are readily available and accessible to them. God knows what the children do with those devices. And then they end up in such situation. Because ukiangalia defilement case, inaanza pia from the age of huko 10, 11. Naweza pata watoto wadogo wako tu shule. As young as 11, 12, wanaingia in such kind of activities.
All right. We are speaking to Asya Mohammed. She is an advocate of the High Court. And of course, we're looking at the case that had been presented in court where 3 teenagers are challenging a blanket ban on sex between adolescents. What question do you have? We're looking at a case where teenagers went to court to challenge a ban on consensual sex, if I said it right. Asya, yes. You spoke about the Romeo and Juliet incident. And so I'm looking at the concept of Romeo and Juliet laws, right? So it refers to legal provision. Let's you'll break it down for me later. And it says that it's found in some jurisdiction. It provides provide exceptions or mitigations for statutory rape charges when a consensual sexual relationship exists between 2 individuals close in age. Right? Often to prevent the criminalization of typical teenage relationship and to distinguish them from predatory behaviors. These laws aim to prevent individuals, particularly teenagers close in age, from being charged with statutory rape when no malicious intent is involved, though the specific age gaps and conditions vary by jurisdiction. Does this apply in our Kenyan law?
Yes, a lot of incidents have taken the same pace. I don't have one particular case law to buttress my point, but I get to see such kind of incidents happening around the legal fraternity. So you can see that somebody is of the age of 17 and the other 16. So most of the time, if I was to fit the shoe of a prosecutor, I would impose such kind of common law statute. Yes.
Okay. And if we're looking at this, because we've had she's from the children's court. Yes, and we've talked about children in conflict with the law, right? So we're looking at an incident where these are teenagers who are in a relationship, right? And from this case they say that it was consensual. But then there's also the case of children who are in conflict with the law where a minor has defiled another minor, right? What's the thin line here between children in conflict with the law and now the Romeo and Juliet case?
You see, that is just a mitigation. The Romeo and Juliet is a diversion tactic. The DPP have that discretion. They have the power to go back under the guiding principle of charge. I think so. There's something like that. So they have that mandate to see. Even in the Children's Act, there is a diversion mechanism there that is spelled out. So they have those mandate to see if this case can it be mitigated, or this case needs our utmost attention, and justice must be had and must be seen done. You see, so it varies from case to case basis. So in such incident, if I was to wear the shoe of a prosecutor, I would use that kind of power to counsel these children, to warn these children. If you ever if we ever find you in such kind of this, the law will take its course. You see, we give them warnings, we give them counseling, because at that time perhaps there is no malice, like the definition of Romeo and Juliet. There is no malice. There is no bad faith around it. It's just that they didn't know whatever they're doing is wrong. Or they didn't know the consequences of whatever they're doing.
I like that. What then is the minimum age where a child can actually have carnal knowledge, where we say it's now know about sexual intercourse between two people in our law?
According to the Children's Act,
yeah,
a child of the age of 12 years, if I'm not wrong, they are termed that they have knowledge to commit a crime. So ukifika hapo 12 years, you are seen to have knowledge to commit a crime. Yes.
Okay.
But according to the Sexual Offences Act, you at the definition of defilement iko na stages hapo tayari. Inajulikana ukiwa umedefile mtoto that is of the age of 17 years and below, that will be termed as defilement. Na kama umeingia into a sexual engagement with a person of 18 years but did not consent. You know, consent ni muhimu. The term consent did not consent. Now that will be phrased as rape, because yule is an adult. Adults, they are being raped. Children, they are being defiled. Yes.
Okay.
Okay. Sasa hii sheria ni ngumu. Sheria ni ngumu.
Anyway, ni tamu.
Si tamu, inatukoroga. Anyway, hapa kwenye hawa watoto.
Naam.
Umetoa mfano kwamba huku itakuwa rape. Lakini huku umesema kwamba kulingana na sheria mtoto ana ufahamu, umesema wewe miaka 12.
Yes.
Anaelewa kwamba mimi hiki ninachokifanya ni sawa ama
sio sawa.
Si sawa.
Yes.
Lakini kule nyuma umetuambia kwamba hii kesi ikipelekwa kulingana na mzazi, tuseme Miriam, yeye mtoto wake ni wa kike, ameghadhabika kwa maneno yako, akaenda akashtaki, sawa, kwamba mtoto wangu alifanywa kadhia 1 2 3 4 5, na mtoto wa Barisa ambaye mtoto wangu ndio wa kiume, so ameenda ameshtakiwa, lakini haelewi. Lakini huku miaka 12 anatambulika kisheria kwamba
anaelewa makosa.
Mbona hapa mahali kidogo? Ama the law is not clear.
The law is very clear. Wote wana miaka mingapi hao watoto?
Ni hao wa miaka 17 na
15 and 17.
Hapo, yes.
15 and 17.
Yes, hiyo 12 mpaka 17.
Exactly my according to the sexual, you know, this clause, they complement each other, you know. Ndio maana ipale ikisema mtoto of the age of 12 years and above, I mean paka hapo 17 tuseme, they have the ability to know what is wrong and what is right, so they can be in conflict with the law. Waona how tayari they fall under the description of that's why they can be charged.
Okay.
Ndio maana unapata mtoto atakipelekwa kule anakuwa charged. Mtoto below 12 years hakui charged sana, unaona? But 12 years and above according to the Children's Act wanakuwa charged. So in the Offences Act inasema anybody below the age of 18, any is a child. And that child engage into such kind, whether a child with a child or a child with an adult, they are categorized as defilement. They have been defiled. Yes.
Okay,
so there is no exception. They all complement each other.
Now the question is ni pale mahali ambapo Miriam amekuwa ameshikilia. Now kwa nini sasa hapa kama huyu anatambua, mbona huyu mwingine ndo anabandikwa mzigo?
Like what's the basis of charging one minor, you know?
Na wote walikubaliana.
Yes, and not the other.
Ndo nasema sana.
Yeah.
Unapata mtoto wa kiume ni nadra sana kwenda polisi kusema mimi nimekuwa defiled. Very few. Waweza kuwa wote ni 17, 15 and 16. But hakuna mwanamume ninavyojua mimi, according to my own knowledge, that will come, because kuna ile stigmatization wako nayo. Mimi mwanamume nitaenda niseme nimekuwa assaulted or nimekuwa defiled ama nimekuwa raped. It's very hard for men to come out. You're getting my point? But for ladies it's quite easy. Especially sometimes it's not even the child that initiates this, it's the parents, because ama the guardians wako nao. Unapata mtoto tayari ashapata mimba. There are so many incidents that are not being reported. Na watu bado wana engage uko nje. Na ni watoto still. Lakini zile ambazo zinakuwa reported, majority of the time unapata mtoto labda ashabandikwa mimba. Sasa yule mzazi ameshtukizia time mtoto wake ako na ball. So ako like, we hii ball umeitoa wapi? Ni nani? Utanieleza, utafanya nini? So hapo mzazi ndo anaweka mikakati. Anakuwa na ile adhabu, anataka justice. Unaona? Mtoto wake ameharibiwa. Hajui labda mtoto wake ndo labda yeye ndo initiate to begin with. So anaenda polisi, ana raise complaint yake. Polisi wanaiona huyu ni mtoto underage. Kisheria hafai kuengage into something like that. Whoever has done that needs to be arrested, investigated and arrested. Akishika ni minor ndo wanachukua zile wanapeleka kwa DPP wa recommend. Wataelezea sisi tumefanya uchunguzi wetu, hii ndo file yetu, hizi ndo ushahidi zetu. Unaona? Sasa wewe kama prosecutor, because according to our constitution under article 157, the DPP are mandated, they have the power to charge each and every one of us that has committed a crime. Wao ndo wako na zile powers.
Okay, so let's look at the case in Kilifi. So it says the Kilifi court blocks Director of Public Prosecution's attempt to sanction defilement as marriage. The court stopped an attempt by the DPP to resolve a defilement case through diversion by approving the marriage of a 16-year-old girl to the 22-year-old accused. The court ruled that child marriage cannot be disguised as settlement, ordered the man's rearrest, and directed that the minor be returned to school. Break it down.
Well, hapo kuna kamzungumkuti because first and foremost, lower court, they do not have the mandate to direct the DPP on whether to charge or not to charge, because they or even cannot be seen to influence that kind of initiation, because according to the constitution that fall under the DPP's docket. So the court directing the rearrest, and when you say rearrest, that means once they are arrested, they are going to be charged and brought to court, isn't it? So I must say that the court acted ultra vires. They went beyond their scope of power. So in that incident, I believe that the DPP might come again and challenge that court order and so on and so forth. I don't know what is happening currently at the court, but such kind of incident, as you can see, 16, again, 22. The age gap is not pretty much big. 16 and 22, that's like 6 years, or?
22 is an adult.
It's an adult, yes. Or even you can on 18 to 16. Does this mean that we are supposed to go back to the drawing board and reassess the age of consent? Should it be now 16 years? Because ukiangalia, they are teenagers in Nairobi, they want their right to consent. And then kuna hii incident ya marriage in Kilifi of a 16-year-old. Ameolewa, ame consent, yeah? Because for you to get married, you need to consent. And there is also the notion of religion. For Muslims, for us Muslims, when you reach the age, when you reach puberty, wewe uko tayari kwa ndoa. Yani waeza oleka so long as ushaingia ile age ya puberty. Na age ya puberty ni hapo 13 kuendelea. You getting my point? So should we again come back and debate and readjust the age of consent?
Is it a matter of readjusting the age of consent, or because I know you also mentioned introducing sex education in schools?
Yes.
Is it a matter of readjusting, and how would it look like even if you're readjusting? And also, when it comes to introducing sex education, should more than be done in schools?
Yes. Actually, let me tell you a fun fact. Before the age of majority here in Kenya being 18 years, it was 16 years. And then they amended and made it 18. But zamani ukiwa 16 years unapata ile kibali. Unaeza kwenda kuvote. And then wakaongeza miaka to 18 years. So then sijui what was the rationale for 16. But this one, and wakaongeza to 18. But right now, currently, based on the current affairs, based on the change of culture and narrative, do we have to go back to our roots? Do we have to go back to 16 years? And then when it comes to comprehensive sexual education, I think it's very important to bring that in schools. It could be at a higher level. Because ukifika hiyo age of 16, 17, you're already in the verge of transitioning to upper education, going to university, going to college. So at that particular age set, it's very important to introduce that kind of curriculum whereby they are being taught in detail, in a formal way. It's no longer a norm, it's no longer a taboo, because in most African culture ni nadra sana utapata mzae amemkalisha mtoto chini anamwambia mtoto wangu it's A, B and C. These are the reality of life. We shun away from such kind of information.
All right, we've been speaking to Asya Mohammed. Asya, thank you so much for making time today. What's your parting shot as we wrap up?
I think it's a high time we evaluate and comply with the kind of customs and practices that are already trending right now.
All right then. Thank you for making time. In a bit, we're going to speak to the chairman of Boda Boda Association.
Yeah, that is Samuel Ogutu.
Yes. On the Boda Boda menace in relation to the accidents that we see and the aftermath. And the aftermath. We'll be right back.